Mr. Anderson, you may continue.
Did there come a time that you began taking photographs of Maya and her different symptoms on your own?
Yes, within the hospital, yes.
All right. And why did you do that?
There was many times that we reported something and they denied or did not take care of, a lesion or her dystonia, things like that. So I started taking pictures. And then after reading some of the medical records don't even indicate that she has a lesion or so. And we have a picture on the same date where she has lesions.
Can we put up these photos, some of the photos, run through them?
You have an exhibit number there?
It doesn't have, I'm hoping you guys have the Kowalski photos.
Do you have an exhibit number?
That's what we're looking for right now. It's not on my outline. While we're finding those, what we're going to do is play the remaining two of these videos, if we could. One is 2703C. We can do that. Now, Maya pulling her knees up to her chest like that, what did that usually indicate to you?
Well, did you see her? She pulled her knees up, but did you see her use her hands to pull her legs up?
Yes.
And then also, I don't know if you noticed, she has a thing on her forehead. That's for the sensitivity of light. She has a little eye mask or something to cover her eyes if the light's bothering her. But when she got into the bed, I don't know if you've seen it or not, but she actually physically used her hand to lift up her legs.
Now, from your knowledge of CRPS, is light sensitivity one of the symptoms? Or
That is one.
Objection, predicate.
Overruled.
Sorry.
No, you can finish your answer, sir.
Yes, it is.
All right, let's play 2703D.
They're only supposed to be like $1, right?
Yeah,
Or like really cheap.
$1 is
Yeah.
like normally $1.50, but the more shopping for that, the cheaper.
Oh, really?
Since she has your medicine, which it should be helping a little bit, I want to try to use the walker just to stand, pivot, get in the chair, like you did with Becky a bit. So I'm jealous that she got to see it and I did not. So I'm going to help you, but I want you to try to get your feet flat on the ground. I'll hold you up, just get your feet flat. Put your feet down.
You got it. Good job.
Turn the walker.
You got it.
Better than yesterday. Hey, give me a high five. That was awesome. Better than yesterday.
You got it.
I wish we had the feet for you. That was awesome. Great job.
It's going to hurt just a little bit because you haven't put any weight on the leg.
Were you able to hear her moaning and crying?
Yes.
Is that similar to what you heard previously when your daughter was in significant pain?
Yes, and sometimes it could be worse. But as you could see, she was trying to use her arms as much as possible. That's not a child faking.
And does this demonstrate, based on your knowledge of your daughter and the times you were seeing her at this time, the type of shape she was in?
She was getting worse.
As she entered the hospital, was she almost to the point of getting up on a walker and maybe with just a tiny bit of assistance getting around before the relapse?
Yeah, before the relapse, she was outstanding. Upper body strength was extremely well. And like I stated earlier, there was a picture where she's actually using her arms to support her whole body off the ground. She looked like a little gymnast. But no, now we just see her going downhill again.
Did Maya report to you during this period of time that this physical therapy, as opposed to warm water therapy, was actually hurting her?
There
Although
was
we
no
see it.
warm water therapy here at the hospital.
So was this therapy painful for her?
Yes.
And she
And
expressed
it's
that.
usually not, that don't appear to be the proper therapy for CRPS.
What's wrong with it?
It's too quick. You got to do things at a certain pace. I don't know if Rachel explained that from agility. You have to, first of all, build up certain things. And I believe the young lady from Tampa General, she also stated that. You gotta do it in steps.
Okay, so let's then jump to the photographs that you took that we alluded to just a moment ago. And I believe yeah. After October 20th, Nick has reminded me, after October 20th, when you witnessed or when you visited, did anyone tell you at the hospital about the video, that is, the one that had just completed, about Maya's difficulties in the surveillance room?
Not at the hospital, no.
And had you had that complete video, would you have used it to demonstrate that your daughter actually was doing a lot worse than being represented?
This would have helped paint the picture to the judge.
Sustained.
I'm sorry.
Was that video of value to you in defending your family?
Objection calls for speculation, Mayor.
Sustained.
What, if any, use would you have made of the information had they told you about this video?
Same objection, Mayor.
It's not speculation.
Okay, you can answer that question.
We would have took this video to prove Maya's condition. They were, unfortunately, it was a one-sided story. And we had if we had this would have painted a better picture to the judge at that time. And we probably wouldn't be here today.
So let's go through the lesion photos if we can. 2571-001. And after each one, I'll ask you to just kind of tell the jury what they're already seeing.
Your Honor, I apologize.
Approach.
Yeah.
Jury, I'm going to ask you step out for a few minutes. Do not discuss this case amongst yourselves. Do not do any investigation and receive no information. presence. Now, Mr. Anderson, I know we've discussed this before we even got to trial. The information was the plaintiff's attorney had this video, was it November 6th or November 7th?
No, later. The date's important.
Okay, well, tell me the order I entered on this. Give me the DIN number on that, because I distinctly recall it was like in early November,
Mid-November, Your Honor, you're correct.
mid-November.
Yes.
Okay.
And just prior to that, there was a dependency review hearing on November 8th and November 10th. And Mr. Kowalski did not have this video or the benefit of it during the dependency review hearing. That's his testimony, that would have benefited.
It's not exactly what he said.
No, it
And
isn't
it's
what
also contrary to both the order and the implication, because the specific order from the court was the plaintiff can't contend.
Can someone give me a DIN number,
Sorry,
please?
yes, Your Honor, the DIN number is 3032.
3032.
For which now? For the actual hospital video?
This is the order limiting false imprisonment until after that date of November 16th or something.
I guess November 17th, not November 7th. I agree with the defense on this, Mr. Anderson. As of November 17th, there can be no concealment issue with respect to this video because the plaintiff's or Mr. Kowalski's attorney had it.
Judge, at that time, we did not have all of the information from Deborah Salisbury, and
Are
here's...
we all working on a curative instruction at this point?
Yeah.
Because one's coming.
I would ask that you, and we can bring Deborah Salisbury in, this is all planned. And I did not understand the limitations on this video being provided to Deborah Salisbury. Here is her testimony. We can bring her over here right now to do it. Her testimony
You
is...
didn't understand. The court grants the motion to the extent plaintiffs seek to contend there was any fraudulent concealment on or after November 17, 2016 relating to the secret video surveillance. What did you not understand about that?
I would like relief from it.
Okay, well, that's not what you just told me. You told me you didn't understand it.
Well,
So
maybe I got the... I got
you're
the...
asking
Wait.
reconsideration, or are you telling me you didn't understand the court order?
What I did, I may
Can you
not have
answer
gotten
my
straight.
question? Please answer my question.
I think I got confused on the court order as to the dates. That's the only thing and frankly, that was not the purpose of my question. I just asked whether it would be useful for him.
So the next decretal paragraph, the court denies the motion to the extent plaintiffs seek to contend there was fraudulent concealment prior to November 17th.
Judge, that's for the count on fraudulent concealment, is it not?
So are you saying this is medical malpractice?
Yes, and I'm also saying that it's part of our intentional infliction of emotional distress.
Well, to the extent that you are saying that there's an issue in the dependency court, you got a Chapter 39 immunity problem.
I
So you
understand
can't
about
do that.
But I think what I can do is show the basis of what was happening there in terms of whether Ms. Salisbury actually had enough of the video. And what the evidence will show is that it was brought over to, or she was brought over to defense counsel's office, not at DCF, but at Hill Ward and Henderson, and was shown snippets of it on the basis and telling her that this video, all this video shows is that she's in bed and we're going to use it to show that she's moving around. Ms. Salisbury asked for it. She didn't get it. She finally got it. Then by the time that when she got it, she couldn't open it. We've had that problem before because she didn't have the codes to open it. So during the pertinent period of time, she did not actually have the video. What she had seen were about 3 different 2 to 3 minute spots, and what they were telling her was, we're going to use this to prove that Maya Kowalski can move around easily. And so the problem is, she did not have, and we did not have until this litigation, the complete video to be able to look at it and pull out the things that the court just saw. And so we intend, if the court will allow it, we intend to show through Ms. Salisbury that contrary to their representations, and insofar as this being part of the Chapter 39, Hillward and Henderson was not supposed to be a prosecutor or a defense attorney in this. They were simply supposed to be a participant. So why they had this tape and we're going to show it and make representations about this is another issue. But to the extent the court believed that Ms. Salisbury had the complete use of it, and therefore that is impugned on the plaintiff and then impugned onto our representations, that is a false statement. What Deborah Salisbury had were isolated clips under a representation. As a good counsel, she asked for it to receive it. When she first received it, it wasn't from DCF. It was from Hillward and Henderson. And so at that point, she attempted to open this thing. This is going to be her testimony. I'll bring her over right now if we need to. She attempted to open it, could not open it, had to obtain a code, a special means of showing this. Apparently it's coded some way that's difficult. And I'm not sure the timing after that, but I do know it was late in the proceedings, very late in the proceedings.
Well, one, you told me the issue that Ms. Salisbury had about 6 months ago, and I think you also talked to me about it 2 years ago. And you did not bring any testimony from Ms. Salisbury at any time. I don't recall after I entered this order on May 8th, 2023 at DIN 3032 that you filed any motion for relief from that. The time for discovery is over. Trial is not supposed to be by ambush in the state of Florida. Everyone's supposed to know, both sides are supposed to know what each side has. And I am sorry that you seem to misunderstand the court's order talking about this issue.
Only as the timing, really.
Before and after November 17th, I don't know how more clear I can be, but be that as it may, I'll grant you that you might be confused as to the meaning of November 17th. I need you to try the case and not continue to be on discovery. We were ahead. The last couple of days have been very bumpy, and we're starting to slip. We've got a jury that continues to go out to deal with issues that should have been addressed before we even selected a jury. But we're at where we're at. Discovery's over. Trial. We're going to live with the orders that were previously entered. If you don't understand an order, please let me know. Hopefully timely.
In our defense, I believe that was an order in limine.
It was an order granting and denying.
Regarding summary judgment on count 20.
I believe there was a follow-up motion in limine, and what I understood from the court was that since we had, I don't know how many motions in limine in this case, going into the dozens, that if there was an issue which arose at trial, that the court would reconsider.
Outside the presence of the jury.
I didn't know he was going to say that, Judge. I just asked him if it was of value to him.
Yeah. Well, and
And the
the
next-
reality is, well, let's just go with what do you have
I'll
a
be
recommendation for the proposed
I'll
curative?
make the recommendation that Mr. Alderman will make it, but here's the reason why this is extremely problematic. The video, as Your Honor noted in his orders, was turned over to Ms. Salisbury on November 17th, 2016. After the Kowalskis received the video, there was a shelter hearing on December 5th, 2016, and there was a shelter hearing on December 13th, 2016, both of which at a minimum would have been opportunities for the Kowalskis to present Whatever evidence was in that video to the DCF court. So there's been a false implication in front of the jury that video, if provided timely, would have changed everything and Maya would have been home. It's also relitigating the DCF action, which this court has instructed both parties on numerous occasions not to do. My colleague, Mr. Altenburn, is working on an instruction, but we're very, very concerned about the last statement from Mr. Kowalski on the witness stand, that if we only turned over the video, everything would have been different. It's a clear violation of this court's order. It's a complete misstatement of the facts that the video was in the possessions of the Kowalskis for 2 subsequent hearings. And I think we have to move for a mistrial at this point, Your Honor. We would reserve on that until the close of the case, but we do have to mark for the record that we are moving for a mistrial on that basis.
Well, are you moving for a mistrial or are you not moving for a mistrial?
Yes, we are moving for mistrial. We'd ask the court to reserve on that.
Joe?
What, Mr. Altenburn, is your proposed language?
Your Honor, on the fly, I think from what I'm hearing that you should tell them that the jury is to ignore the testimony of Mr. Kowalski, that the videotape that was produced on November 17th would have made a difference in the DCF proceeding, that the hospital is not responsible for the orders entered by the court in the DCF proceeding.
Is that written out or is that?
No, I'm taking from my very bad handwriting to do that.
If you say it again, all right?
Yes.
Can you read that to me again?
Well, the
So
court
I'm
reporter
just
took it
recite it
down.
again.
The court reporter took it down.
Can you read it
You want
back?
me to read it?
Yes, that's probably better. You can go from there.
Your Honor, on the fly, I think what I'm hearing that you should tell the jury is to ignore the testimony of Mr. Kowalski that the videotape that was produced on November 17th would have made a difference in the DCF proceeding, that the hospital is not responsible for the orders entered by the court in the DCF proceeding.
One point, Your Honor.
Your thoughts, Mr. Anderson?
First, for the record, the December 5th and December 13th hearings were not on any merits of the case. They were purely procedural to deal with how Maya Kowalski was being treated and how the orders were to be modified in regard to that. So there was no opportunity at those. Our concern in this, besides the fact from the defense's perspective, it just merely highlights the testimony. Our concern is this: until the court hears Ms. Salisbury's testimony completely, which I have summarized but by no means have made complete, we believe that it's objectionable to read any instruction that would diminish the plaintiff in front of the jury. And really, the question did not call for it. I'm sorry it went farther than I anticipated, but it was not intentional in any way, shape, or form. And until the court has all of the facts in this to make a determination, we do not believe that an instruction is important. We have to put on our whole case and at least get to Ms. Salisbury's testimony. And then the court can decide what it needs to do. For the record, I'd point out the number of orders in limine in this case makes trying to examine a witness a veritable minefield. And I simply wonder, given human beings being human beings, how it's that it's going to be very let me say this: it's very difficult for me up here questioning to constantly have to weave around these orders. That's the problem with trying the case in limine. So I understand the orders are there. I understood that the court was open to them. as to the summary judgment, the only thing I got mixed up on was about the November 17th versus the dates that mattered.
Here are my thoughts. In response to Mr. Anderson's point, we'll just wait until we hear from Deborah Salisbury. The problem with that is, even assuming that Ms. Salisbury could not open the video, she had knowledge of the video indisputably no later than November 17th, and could have sought relief in front of the dependency court if she was having trouble opening it up, and could have addressed the issue in front of the dependency court. So here's what, based on what Mr. Altenburn said, let me read kind of where I'm at, but this is not a ruling. This is, let's just listen to it. The videotape that the jury has been seeing and discussing, or sorry, the videotape that the jury has been seeing most recently this morning was provided to the Kowalski family attorney on November 17th, 2016. The jury is instructed to disregard Mr. Kowalski's statement that the video would have made a difference in the dependency action. To be clear, defendant Johns Hopkins All Children's Hospital cannot be held responsible for court orders entered in the dependency action.
I think that's fine.
Your Honor, the second sentence there, that it would not have made a difference, implies that it could not have made a difference in the time before November 17th.
And that's our problem.
And that's our fraudulent concealment count is based on.
So would not have made it after November 17th?
Yes,
And it
that's
depends on
fine.
how much evidence we want to get in on this, because I mean, there were two lengthy hearings on November 5th and December 5th and December 13th.
Procedurally.
And no one raised this then saying, we want to use this to change orders or to do anything. And so then the argument's going to have to be that they would have done something in that 30-day period that they didn't do in the 30-day period after they had this, and when the hearings were also taking place. So this becomes sort of an inference on an inference kind of problem as to what a judge would have ruled if he'd known something on November 10th when they didn't give it to him on December 10th once they had the
I think
document.
we're now re-arguing the summary judgment. The court made its decision November 17th is the cutoff deadline. So we're allowed to pursue this up until November 17th. There were two shelter review hearings on the 8th and the 10th, lengthy, full-day hearings, where Mr. Kowalski had no knowledge of this video.
And they had a duty under their statement.
Time out. I think Mr. Whitney has a point. So the second sentence, let me read it and get everyone's thoughts. The jury is instructed to disregard Mr. Kowalski's statement that the video would have made a difference to the extent that such statement applies on or after November 17th, 2016 in the dependency action. To be clear, defendant J. Hatch cannot be held responsible for court orders in the dependency action.
So to be clear, does that mean I'm going to have to start arguing and having evidence on relitigating the DCF and things and bring in people about whether it would have made a difference in the 30 days earlier? Because, I mean, we're opening the can of worms that you didn't want to open.
It's a can of worms that was opened in the summary judgment orders. It's been read multiple times. It's been known to the defense that this was an issue.
It's been known to me what we were going to try the case on, that we were not going to try the DCF case based on orders that were entered long before this trial began, Your Honor. And
His
now,
testimony is in the hospital.
Time out. Can we just have one at a time, please? count 20 has been limited to the time period prior to November 17th.
So the question, Your Honor, I think is, can Ms. Salisbury or some other lawyer get on the stand and opine as to what she would have done if she had been technologically capable of opening this when she claimed she couldn't, and what arguments she would have made, what arguments the DCF would have made, because John Hopkins wasn't a party, wasn't even attending those, and what ruling the judge would have made. We're stacking a whole bunch of circumstantial things together that looks to me like we're going down a black hole.
Well, I mean, anything after November 17th, we're not going there.
Yes.
That's clear. Count 20 specifically talks about the video surveillance.
Never really alleges that Ms. Salisbury would have done something different in that time period, to my recollection. It was very unclear what they were going to do, or that what they didn't do in reliance on the fact that they didn't know about this.
Well, I guess the best I can say at this point in time is count 20 prior to November 17th is a live count in this case.
I'm sorry, Nick was talking in my ear one more time.
It is a live count. I mean,
Yes.
I guess, again, I guess we have to wait till see whether they put her on the stand, but if we do that, it kind of changes what I visioned the scope of this to be as we were entering in it through pretrial.
I'd prefer to just take it one step at a time. If I'm understanding the court correctly, the last sentence was that the count remains alive.
Well, count 20 still is a live count to the extent it's prior to November 17th. Now,
That's fine.
I'm going to reread the instruction one more time and see if there's any more tweaks that we need to give. The videotape that the jury has been seeing most recently this morning was provided to the Kowalski's family attorney on November 17, 2016. The jury is instructed to disregard Mr. Kowalski's statement that the video would have made a difference to the extent that such statement applies on or after November 17, 2016 in the dependency action. To be clear, defendant Johns Hopkins All Children's Hospital cannot be held responsible for the court orders entered in the dependency action. Any other?
Yes, Judge. Technically, it would be the prior attorney, so I don't want to diminish my standing before the jury. So rather than saying her attorney, can you say her prior attorney? Or prior
Or the
counsel?
family's attorney at the time.
Yeah, the family's attorney at
I
the
don't-
time.
How about the Kowalski's family attorney in the dependency action?
Right.
Perfect.
But by the 17th, did they have separate lawyers? I don't know when that at one point, and I think it's before the 17th, he had a lawyer and she had a lawyer. So there were two separate, I mean, he's testified to 4 lawyers, and that's what he's talking about, is that they ended up having 2 different lawyers pretty early on.
And
just
Ms.
don't want to-
Salisbury represented who on the 17th?
I think Jack Kowalski.
I think that's correct. And there was new appearance for Beata Kowalski.
So,
In fact, I can,
so why don't I just say to Mr. Kowalski's family attorney in the dependency action on November 17th?
That's
I
fine.
think I may have the answer to this. Hang on.
Mr. Altenberg, any other?
No, Your Honor.
And Mr. Anderson, did you want to say anything on the mistrial motion?
Judge, the error, and we're not conceding there was, but if there was error here, it certainly did not go to the point where it would so prejudice the jury in their review, particularly with the instruction, which I think cures anything. I would simply point out that this case is incredibly complex and difficult to try for anyone, and I'm sure with the court too, with the number of orders in limine and summary. We have 52 summary judgment orders, and I've lost count of the number of orders in limine. I believe in this case that there's going to be more than one incident where a question brings out something, no matter how much the plaintiff's counsel instructs witnesses, including their client, no matter how much we instruct them, they're human beings. And they don't go as programmed a lot. So my concern on these motions are that the defense wanted them entered And now we should have some understanding of the difficulty in this case, and that really at this point there is completely insufficient problems to impress this jury to the point where they cannot receive a fair trial, particularly with the instruction.
Anything else, Mr.
Very,
Shapiro?
very briefly, the reason for the mistrial is not simply a violation of a motion in limine. It's intentionally walking a witness through questions that knowingly were going to end with a response that if only something was given to me, the dependency action would have turned out differently, implying that all children is responsible for taking Maya Kowalski away.
That is-
I believe this is the third time that the court has had to give a curative instruction to this jury in this short trial that we've already been through, telling this jury all children is not responsible for, Maya being taken into state custody. And so it's the cumulative effect of all this. It's not just merely a violation of a court order, but we believe at this point the intentional walking a witness to a statement that this court's instructed multiple times is not a subject to the litigation because we do have immunity. Thank you, Your Honor.
I categorically deny.
Time out. I'm going to deny the mistrial motion. I will say, honestly, I think that the trial has been cleaner than I anticipated it was going to be by this time. Honestly, and that's a tribute to the lawyers. And I think the credit needs to go to the lawyers. The concern I had when that question was raised, which has been articulated by Mr. Shapiro, is the impression it gave to the jury that somehow this video would have caused none of this to have happened. And I think that this curative instruction specifically and directly addresses that perception that Mr. Kowalski's statement could have been given to the jury. And it's done timely, it's done right away. And so I don't see a basis, I don't see a cumulative basis for a mistrial. I'm comfortable with this curative instruction, and I'm confident will ensure that this jury does not take a false implication from Mr. Kowalski's statement. Okay.
Well, yes, Your
I'd
Honor.
really like to bring the jury back in.
And I really want to not get another mistrial motion, so I wanted to ask the question. The question that was coming next was this, would this video have been of value to you? And he knows not to say anything about substituting it in or reopening the proceedings. But there are two things it's good for. The first is for him to understand what was going on with his daughter, and that goes secondarily to the damages in terms of emotional distress and so forth.
Well, I'm assuming that you are restricting your question to a date range to which it applies. Yes.
That's the case.
Right.
And Your Honor, just to make something clear in the record, I've checked my personal notes, having read the transcripts in the DCF proceedings, and it appears that on November 10th, Ms. Salberry appeared for both parents, and then on December 5th, they each had separate counsel. So sometime in between there, and I cannot tell you whether it's before or after the 17th, that there was a substituting of counsel. I can actually look at the docket on that and figure out the data.
I don't think for purposes of the curative instruction it matters.
I don't think so either. I just wanted to be honest about
Thank you.
that.
I appreciate that, Mr. Altenburg. Anything else, or can we bring in this jury in?
Nothing else from the.
And let me ask, how
Am I
much longer do you have in direct? Because you told me yesterday it was 1 hour.
Yeah, yes, Your Honor. It's been a really difficult extended hour. I would say I'll never finish by lunch.
Okay, so we're going to go to lunch while he's still on direct?
Yes, sir.
Okay. Let's bring
And
in
I can
jury.
ask that would have been of assistance to him. That question.
It's going to be objectionable.
I touch that again if you like. But it would have been of assistance to him in knowing you were asking him a legal opinion.
Okay, please be seated, everybody. Okay, members of the jury, I want to confirm while you're away, you did not discuss this case amongst yourselves, you did no investigation, and you received no information. Is that all correct? Correct. And that you did not look at any media coverage concerning this case while you were on break? Correct. And no one approached you about this case, is that correct? Correct. Okay. And members of the jury, I'm going to give you another instruction at this point in time. The videotape that you as the jury have been seeing most recently this morning was provided to Mr. Kowalski's family attorney in the dependency action on November 17th, 2016. The jury is instructed to disregard Mr. Kowalski's statement that the video would have made a difference to the extent that that statement applies on or after November 17th, 2016 in the dependency action. To be clear, defendant Johns Hopkins All Children's Hospital cannot be held responsible for the court orders entered in the dependency action. You may continue, Mr. Anderson.
As the court has related, the video was taken October 18th through 20th. Now, on or before that date, did they tell you in any way, shape, or form that they intended to do a video surveillance in a separate room of this nature?
No.
And if they had, would you have consented or not consented?
I would not have consented.
Did the hospital tell you at any time in October 16 that they had taken a covert video of your daughter over 48 hours in mid-October?
Objection, Ms. States Evidence.
Overruled.
No.
If the hospital had told you about the video before November 8th and 10th, what would you have done in terms of objection? Would you have objected to this video going outside the hospital?
Yes.
All right. So in reviewing this video, when you finally did get to view it, did it affect you emotionally to see this happen?
Yes.
And knowing your wife, would it have affected her?
Definitely yes.
Okay. Now, let's continue, if we might, on the lesion photographs. We were at 2571-001. All right, you recognize this photograph?
I do.
And what is it of?
It's a lesion.
Approximately when did you take this photograph?
There's a date on the bottom, 10/8/2016.
All right, let's go to 2571026. All right, so 2571026, what is this a photo of?
It's a photo of Maya. And there's some lesions. I see one on the forehead and maybe on her left knee there.
All right, let's go to 2571-030. And what do these reveal?
There's more lesions, right and left hand, and then also her forehead.
So this is as of December 24th before Christmas?
Yeah, Christmas Eve of 2016.
2571-053. So this is of a date some, 2 weeks before, no, a week and a half after?
Yes.
And is this the same lesion, unhealed, that appeared in the prior photo?
That is correct.
How long would it take a lesion to heal if they did?
Objection, foundation, call.
He can observe.
Overruled.
I honestly don't know how long it takes to heal. I think Dr. Chopra mentioned that, but I'm unaware.
And then let's look at 2603. looks like, well, that's date of admission. Do we have a date on this one? Yeah.
It's
January
January
1st, 2017. It's in the handwriting.
So, there you go.
That's another lesion.
Okay. And we'll ask about that in a moment. And then 2604. And is that another lesion?
Yes, it is.
All right. So the lesions that you saw there, were they in existence, to the best of your knowledge, prior to January 7th of 2017?
Objection to the leading, Your Honor.
Overruled.
There was lesions. I did document it in my notes, along with taking some pictures and also advising the staff.
Okay. I'm informed 2604 has 8 photos. Let's continue on with those. Now, that last photo and this photo, looking at the pants and the situation, do you know who took these photos?
I was going to say, that's not mine.
Okay.
I don't believe so.
All right, continue. And continue. And is that a lesion on her hand?
That is a lesion on her hand, yes. Left hand.
All right, continue.
Lesion on the forehead.
Continue. Now, are you familiar with this photograph?
Recently, yes.
At the time, did anyone tell you that they were going to take off some of your daughter's clothing to try to check her for lesions?
No.
And the prior two photographs, having seen this one, were they photographs of your daughter in this series?
Yes.
Continue to the next one. Well, first, do you see, you can only see half of her face there. But knowing your daughter, what is her reaction here that she's showing?
It's hard to see her whole face, but looking at her lips, she doesn't seem happy with what's going on here.
All right, next photo. And now she's down to what, a training bra?
That is correct.
So, did you ever give Kathy Beatty or anyone at Johns Hopkins All Children's Hospital permission to strip your daughter and take photos like this?
No.
Next, please. Is that the last?
That's the next one.
Okay. And then, did we cover 2603 and that was 2604?
This is 2604 dash 8.
All right. So, make sure we've got them all in. When was the first time you learned that your daughter had had this happen to her?
It was around the time after, I believe, she went to court in December or January. I don't know exactly what month.
Okay. Did it turn out that this was the day she was to go to court?
Yes, it was. She was going to be evaluated by Dr. Duncan.
And again, did anyone call you and ask you about this?
No.
Let's show the remaining photos in 2604. Continue. Continue. Now, hold on there. Go back. Do you notice her hand there?
I noticed her hand and then also the arm. You could see discoloration in it. If you go back one more picture, I believe it shows the arm, see that by the elbow area.
And what did that correspond to with your experience with your daughter?
We were told that's a typical sign of CRPS.
And let's go back to the hand. Next photo. And the next photo. Continue on. Do you know if these were taken in her room or someplace else?
I was somewhere in the hospital.
Continue. See the knuckles? Let's go back a little, and that one too. You have a lesion there right below the knuckles.
That is correct.
Are the knuckles red?
Yes.
Tell the jury what that indicates to you, knowing what you know about your daughter's condition.
Another sign of CRPS.
When she had these, did it indicate that she was having a flare-up?
Objection, called foundation.
Overruled.
A flare-up and associated with these lesions, there's extreme pain to the lesion itself.
So when someone would grab her hands in these videos, can you tell the jury the reaction you have seen your daughter have when they touch those lesions?
It would cause extreme pain.
Next photo. Notice the knees.
Yes, I do.
And what does that tell you?
If you didn't know that she had CRPS, you might think they were rubbing against something, but that's a sign of CRPS.
Right. Next photo. And what does that indicate?
That's inward rotation on her feet. That's called dystonia.
Next photo. So here they are pulling up her shirt. Did you ever give them permission to touch your daughter in this way?
No.
Next photo. I can't tell anything about this one. Is there anything we should be looking at?
Not that I see.
Let's continue on.
It's the final photo of the exhibit.
Now, having looked through the photos, can you tell the jury your reaction the first time you saw these?
Okay. I was extremely upset. She's in the hospital. Later, I found that it was against her will. That Kathy Beatty stated that that's the only way she's going to go to the courtroom is to get the pictures taken prior to her.
Objection to the hearsay, though.
It's party admission.
Overruled.
Did Kathy Beatty say anything about that you know about whether Maya would be able to see her mother?
That I don't recall.
We should ask Maya on that one.
Yes, ask Maya.
All right. So they're talking about these symptoms, not these symptoms, but they're talking about, strike that. Did they ever discuss with you their belief that your daughter was suffering from some sort of psychological disorder?
Objection to the foundation that they.
Let's be a little bit clearer with our pronouns.
Did any of the psychological or psychiatric doctors there tell you that they believed your daughter had some psychological problem?
Yes.
And who were those, do you recall?
I am very bad with names with doctors.
Let me see if I can. Okay. Did it come to pass that you were trying, well, once you heard this, did you want to talk to them and question them about it?
I tried at one point to talk to the Dr. I'm going to bosh her name, I'm sorry. Kattenstein.
That's it.
I did see her in the hallway. She approached me. She was nervous. She was looking around. She says, I should not be talking to you. I would like to talk to you, but I should not be here. And she's looking around. And she said she has to talk to both sides of both attorneys before she could talk to us.
Well, was your daughter in part under the care of Dr. Katzenstein?
She was, and I still had my patient rights.
And so,
Or not
she ever
patient
tell you-
rights, rights for my child, I'm sorry.
did she ever explain in any way, shape, or form why they thought that this was occurring or what reasons they had?
She didn't explain it to me. She was just nervous, looking around. She did provide me with her card with her cell phone number on there. But she instructed that, or it told me that she has talked to both sides before she could talk to me.
Well, who's the other side? Do you know?
Well, it would be my legal, Deborah Salisbury, and then the hospital side.
Okay. Now, did any of the other physicians, well, strike that, who brought it up first to say that Maya was somehow faking this?
That'd be a good question for Maya, because Maya was told by many people.
In the hospital?
Yes.
Right. Did it come to your attention that the nurses there were telling her that she did not have this?
Yes.
Did you learn that Maya was having difficulties even speaking to her separate counsel now, having difficulty speaking to her separate counsel?
Yes.
What was the problem there?
Normally, I don't want to get stuck with hearsay here.
Well, you give it a shot. I'm sure they'll let you know.
Yeah. She advised me when she was speaking with her attorney, Kathy Beatty, be outside the room with the door open, right next to the door.
Right. And during the attempted phone calls with Maya and between Maya and your wife, were you witness to or in the room when Ms. Beatty would, not the hospital room, but I'm talking about more at home, when Ms. Beatty would interrupt?
Most of the times, no, I was not. I did hear from Beata, and I also heard from Maya that was an issue.
And what was the problem?
Foundation and hearsay.
Sustain that one.
And so were you having difficulties communicating with Maya, the best of your attempts, because of Ms. Beatty?
I had difficulty, but I didn't have as much difficulty as Beata did.
And how is that affecting her, not being able to, or having her attempts to speak with her daughter interfered with?
It destroyed Beata.
So now, you previously testified that Ms. Beatty asked you or suggested to you or asked to you whether you should just divorce Beata?
She asked me if I ever considered it, which was a very odd question, just come up with something like that.
All right. And have you since learned that Ms. Beatty took your daughter to the chapel there at the hospital?
Object to the hearsay, right?
It's in evidence.
Madam Court Reporter, can I have that question back, please?
Question, all right, and have you since learned that Ms. Beatty took your daughter to the chapel there at the hospital?
It's in Beatty's depot.
Well, I'm not sure where it's coming from, so I'm going to sustain the objection. You can see if you can get it a different way.
Did your daughter ever tell you that Kathy Beatty took her down to the chapel?
Same objection.
No, that's a statement of present condition.
I'm going to overrule that.
Yes, she has.
And did she tell you what the purpose was?
She stated that they went in the chapel and Kathy Beatty would talk to her in there.
Talk to her about what?
Same objection, hearsay.
Overruled.
There was one point that she said that she could adopt her, that she could be her mother while she's there at the hospital. Just all different things. Mom's in getting mental health, help, I'm sorry. Just all different things. Stroking her hair, kissing her.
Did Maya complain to you that Miss Beatty was hugging her inappropriately?
Objection to hearsay.
Statement of then President.
Can I have that question again, please?
Question, did Maya complain to you that Miss Beatty was hugging her inappropriately?
Okay, I'm going to sustain that one.
Did you understand from Maya that Miss Beatty was making Maya believe some, strike that. Did it come to your attention that other employees besides Miss Beatty were making similar statements?
Object to the hearsay.
Done that?
I agree with Mr. Shapiro on that one.
Now we'll ask Maya. All right. So what you testified to before, just now, about the chapel and the things that she said, did you let Beata know about that?
Yes,
What was the effect on your wife?
she was irate.
To what?
She was irate.
So this was, I think, the photo show towards the end of Maya's stay, and also the record reflects that your wife took her life the evening of when?
It was January 7th, January 8th.
So these photos were taken, were they taken in close approximation to?
Very close.
Objection, Your Honor. Foundation, and I would approach on this, rather than speaking objections.
Objection sustained.
During some of your visits, did you see Maya being mistreated?
No.
Did you see
Not
the
that I know of.
nurses taking any action that you would describe as cold or unusual?
No, there was just incidents where I wasn't allowed to leave a computer, or they wanted her passwords for her social media, things like that. Nothing physical that I could think of. There was a nurse that she liked a lot, but I didn't see anything. You know, I felt that they were cold to me because the situation, like I felt like I was a bad person when I walked in there all the time.
And so now, when you learned of the various things the hospital was doing in terms of the photographs and the video, did that cause you mental distress?
Objection, foundational predicate.
Overruled.
It sure did.
And can you describe it to the jury why this was so upsetting to you?
It's so upsetting because I have to go home, you know, and then you know that's happening, and there's nothing you could do. If I snap, I'm going to lose my privileges. It was very difficult for me to hold it in.
Again, object and move to strike based on the time frame.
Now,
Overruled.
did you tell Beata about this?
I did.
Objection, again, hearsay and the time frame again, Your Honor. This is,
Obviously, it's from this.
Well, let's try to be better with our pronoun usage.
Did you tell Maya, Beata, about what we just talked about when I said this, the photographs that had been taken of her, the video that had been taken of her?
same objection, the state's evidence.
Okay, overruled. You can answer that.
Yes, I did. I did tell her.
And what was her reaction that you saw?
Same objection.
Overruled.
She had the same reaction I had. As a parent, I think any parent would have that reaction.
Did you feel powerless?
Yes, I did.
And how did that translate in terms of your behavior?
My behavior, I was very upset at home, but when I went there, I had to hold it in.
Are you by nature a fairly stoic person?
I'm usually very calm.
You try to hold things in?
Yes, a lot's held in.
How about Beata? Was she that way?
Not as much as me. You know, she would let you know how she feels.
And then when you told her, can you describe for the jury that mental distress that you observed, everything you saw, heard?
Objection, hearsay, predicate, and foundation.
Overruled. You can answer.
I'm sorry, could you repeat it again?
From everything you perceived about your wife, how upset was she when she found out that her daughter was being treated this way?
Same objection, Your Honor.
Overruled.
It was extremely difficult for her. It was taking all the air out of her balloon. I mean, you could see that it was just eating at her. She lost a lot of weight during this time.
Through the course of December, how was Beata doing? Was she stable, not stable, moving down, moving up, what?
Beata was still functioning what she had to do, but it was really difficult for her.
How were you two getting along?
Oh, it drove a wedge between us. You know, I'm trying to, to do both, go to the hospital and then try not to bring it home and tell her everything, where it would hurt her. I'm not intending to hurt her with the way her daughter's being treated, but she needs to know.
Well, did she pump you for information when
She would ask me, and then at times I believe she was talking with the hospital as well, but not getting full answers on treatments and that. So that would interfere and make it worse for her as well, stress-wise.
Were you worried about her mental condition through this period of time?
I was always worried about her. Yeah.
Over this period of time, now we're talking about after you learned about the video 18th and 20th and these photographs, did you have some physical symptoms from this distress?
Objection again to the time frame, predicate, foundation.
I just said it.
Okay. Well, let's be a little bit clear about the time frame, but otherwise overruled.
After you learned of the November 18th to 20th videos and the photographs that were being taken of your daughter and of the manner in which she was being treated overall, did you have any physical signs of distress?
Same objection, Your Honor.
Okay, overruled. You can answer that.
Yes, I did.
Tell us what they were.
Number one, anger, loss of sleep, just wasn't myself. Diarrhea. I mean, it takes a lot out of you, the stress.
What happened to your weight?
Same objection, Your Honor, for time frame.
We're talking about the same. Are we talking about in the same time frame?
That is correct, I believe.
Okay, overruled.
And then, did you experience in this same time frame we have defined any symptoms of nausea?
I had nausea. Like I said, I had diarrhea. When I get a lot of stress, it's hard for me to digest food, things like that as well. Sleep, lack of sleep, big time.
Tell us about the sleep. Like, how long do you usually sleep without this level of stress? Compare that to what was going on at this time. That is from the period of your daughter going in and after you learned about the video and the photographs.
Later at the end, it was a lot less. I was extremely stressed out. I was concerned for Maya. I was concerned for Beata and Kyle. Knowing Beata was still trying to do research and things like that, she was up more, and sleep and being nervous and things like that was extremely high.
And then there was the evening that Beata took her life.
Yes.
Before we get into that, I'd like you to explain a little bit about the billing that was going on by Johns Hopkins who was your health insurer at that time?
At that time, I believe it was Aetna Insurance, and that was through Beata's work.
And then did you ever have the opportunity to go over these records to see what they were, obviously, what you were being billed for these services?
Predicate and foundation and time.
Overruled.
At that time, Beata managed the bills, but she would inform me that they were astronomical.
Mr. Anderson, just in the next 10 minutes or so, let's try to find a good breaking point for lunch.
With the court's permission, I'll just end with this Aetna billing. Just a few more questions.
Whatever you want, just within the next 10 minutes.
Right. All right. So when was the first time you had an opportunity to go through that billing? Best of your memory.
Well, after she passed, I had to go on to Cobra through her work. And they
What's
allowed
Cobra?
me to...
I think everybody knows, but what is Cobra?
Cobra, it's just, I was able to stay on that program for a certain time period with the same benefits, but I would have to pay in place of the employer paying most of the premium. So it jumped up significantly.
You remember approximately how much?
I'm guessing it's probably in the area of $1,300. I could be wrong on that.
A month.
That is correct.
And have we put those records in evidence?
Yes, whatever I had and obtained, I gave to you guys.
Okay. So then, did you learn that some of the, or most of the entries there, strike it, how did you learn that most of the entries there were for CRPS?
Objection, foundation, predicate, and the state's evidence.
You already said.
Sustained.
Did you review the records to see what exactly you were paying for through Aetna, or what Aetna was paying for you?
After some time, there was some for charges for CRPS during that time period.
And did you ever determine what percentage of those billings were for CRPS?
I don't recall the percentage.
Okay. All right. And so what happened then after or during this period of time, every time that they billed Aetna for a procedure that they did not do, did that go on your deductible?
Objection, argumentative.
Overruled.
Yes, it did. And then eventually it was, we met our deductible, unfortunately, with all the bills.
And did you have to pay in after that?
There's a lien still today on
How many
some bills. I honestly don't know, but it's a significant amount of money.
that you owe and on some contingencies?
Objection, it's both leading the state's evidence. and lack of
Sustained.
foundation.
We'll come up with something on that. So, once the deductible was reached, did you have to pay out of your own pocket the co-payments?
Once the deductibles met, no, I don't believe at that time we had to pay unless, if you're talking about a copay, something small,
Yes.
I believe we had something, but,
Approximately what was a copay per visit, approximately?
I honestly wouldn't even know.
Okay. All right. That evening, well, let's break right there.
So lunchtime?
Lunchtime.
Okay. Members of the jury, I'm going to excuse you for lunch